Hello, everyone. Welcome to the webinar. Just letting people in from the waiting room right now, so bear with us just a moment. Okay, welcome, everyone. People are coming in from the waiting room, and we'll continue to filter in. This is our webinar about financial hot topics in family law. So thank you so much for joining us. I'm going to introduce Michelle here in just a moment, but this is our webinar today, and I want to just give you a little bit of information about how it's going to work. To introduce myself, my name is Melissa Rosenberg, and I am actually a private practice therapist here in Seattle with a specialty working with clients who are dealing with divorce and separation, early stages, or if they're mid-divorce case, or in the later stages when they're trying to pick up the pieces and move forward in the next chapter of their lives. So that is what I do, but I am also here today as a moderator for this webinar. And what I'm going to do is take questions from people throughout the webinar if there are questions, and I can pitch them to Michelle. The way to ask a question, two different options. You can put a question in the Q&A at the bottom of your screen, and if you do that, it will show up with your name unless you select yourself as an anonymous attendee. So if you would like to show up as anonymous, please make sure that you do that. You can also ask a question in the chat, and the chat is set up so that will only come to me. So if you submit a question in the chat, I'll read it, I'll pitch it to Michelle. I just want to make sure to note that anything that you ask, should be a fairly general question. We can't be answering case specific detailed questions about your situation, but if you have some, more general questions that we can answer that might be helpful today, we're happy to do that. So again, this webinar is about financial hot topics in family law. I'm going to introduce Michelle now, or have Michelle introduce herself, and then we'll launch into delivering some information and taking your questions. Thank you.
Hi, I'm Michelle Dellino. I am a divorce and family law attorney and the owner of Dellino Family Law Group. Today, we're going to talk about financial hot topics. I've been practicing family law for 15 years. We handle all kinds of things from heavy, high conflict litigation to negotiated settlements. Today, we're going to be talking about financials. The webinar today is going to be limited to 30 minutes. It's not going to be a full hour, so it's going to be important if you have questions that you let Melissa know. I will answer as many as possible, but the main idea of today is to give you a brief overview of kind of the things that are going on in family law with financials, the basics that you need to know. We'll take a few questions, but we probably won't get to them all. So if you have other questions, follow up with us later, and we'll put up some contact information at the end. Last thing to tell you before I get started is that I am an attorney, but I'm not your attorney. So anything I talk about today should be taken as information. It's not legal advice. So it's information in general. And if you have really complicated or specific questions, that probably means you should consult with an attorney one-on-one. So that's not the intent of the questions. So I hope that helps. Today, we're going to talk about financials and what are the main things that are happening with financials right now. So something to know is that financials in every case, there's two things that have to be decided in every case where there are no kids. One is, how are you going to divide the debts and assets? Number two is, one party going to pay the other spousal maintenance? Those have to be decided in every case. If you have children, then you add on a parenting plan and child support. So 3 out of those 4 are financially related. So what that tells you is financials are a big deal in family law. They're also a big deal during the case, and they're a really big point of stress. So to think about it like this, let's just talk about, first of all, what you need to get started with financials in your family law case. What do you need? You need financials. The best point of reference I can tell you is to start by gathering your last 2 years of tax returns, including all schedules and W-2s. And then you want at a minimum 6 months of statements in every account that you have. So that's every account. That's an asset or debt account. That's retirement accounts. That is credit card accounts. That's mortgages. That's bank accounts. Every account you have a financial interest in, get 6 months of statements. If you can get a year, even better. And then the next thing you want after that is a minimum of 6 months of statements. 6 months of pay stubs. If you can do a year, even better. That's going to be really important, your actual pay stubs. So when you think about those things, that's a good starting point for you. Best tip I can give you as well is to organize those financials. It'll save you time and money later with an attorney. If you have 4 credit card accounts, take each credit card account, have a separate folder, and say Chase 2162 account, October, November, December. Do it that way. Do it with all of your accounts that way. Have a financials folder and then divide them that way. It's going to save you so much time and money. You're going to be so ahead of the game. That's what you need. When do you need it? You need it any time that you are asking asking the other party or the court for financial relief. If you're going to court to ask for temporary spousal support, temporary child support, attorney fees, any financial relief at all, the court is going to require a minimum of 6 months of statements, 2 years of tax returns, and 6 months of pay stubs. You have to have that. If you're seeking a guardian ad litem or a parenting evaluator, the court's even going to want financials for that because it's going to want to know how much money do the parties have and who should be paying how much. If you, like I said, are seeking attorney fees, you need to show basically what your financial situation is, and so does the other party. If you are preparing for a mediation, the mediator is going to need those financials as well as for reference, and so is the other party. If you are going to trial, you are going to need those financials and probably a lot more. So my point of telling you that is that you need to know your financials will also need to be updated several times during your case. Get that starting point baseline, the list of documents I just told you. But if your family law case goes on for 6 to 9 months to a year or more, you're going to need to update those several times for different things. And those financials will need to be fresh and current. You're also going to want financials that reflect the date of your separation. So if you separated 3 years ago and you're just now filing for divorce, you'll want current financials, and you'll also want financials that represent the values of your accounts at the date of separation. So that's kind of a big special tip to tell you too that will save you time and money, so you won't be surprised by that later. Why do you need it? You need it so parties can be informed to reach a settlement or make a decision, either so you know what is fair to settle on because you know what the other party has, or so the court can jump in and make a decision and knows what they're dealing with. So that's kind of the what, the when, and the why as a base level. Melissa, are there any early questions before I move on?
We have a couple. Yeah. The first question, participant asks, if I'm receiving income from the division of a business owned with a spouse, am I still eligible for spousal support and child support?
Really depends on the circumstances of your situation. I mean, maybe depends on, let's talk about that. And I'll talk about child support briefly, because one of the hot topics I want to talk about is deviations in child support. So if you're wondering, am I entitled to child support? Here's the less than 2 minute overview on how child support's awarded. Child support's awarded based on how many nights a parent has with the children. And it's not by number of nights, it's basically a parent that has more nights than the other. The primary residential parent is the parent who's going to get the transfer payment from the other parent. And then things that are not covered by child support are going to be allocated between the two parties on a proportional share as far as work-related childcare, out-of-pocket medical, educational expenses, and extracurriculars are the main ones. So are you eligible for child support? I don't know. If you're the primary residential parent, maybe, probably, but how much child support and whether the other party will get a deviation, which means we have a standard calculation. Will they have to pay less because they have more time? There's any number of things that can happen. So if you're eligible for support, probably child support. Spousal support, maybe, depends on the financial circumstances of the parties. Also depends upon the distributions and income and tax burdens that you're getting from the money from the business. So you probably need to talk to somebody about your individual situation. I'll take one more right now and then I'll move on.
Okay, another participant's asking, can the financials be addressed and settled before the parenting plan is put into place?
Yeah, but most people aren't going to do that. Most people want a global settlement. Can they be addressed and settled? Yes. But can you finalize a divorce without finalizing a parenting plan? No. You can reach an agreement. A very common way to do that would be to sign, everybody agrees, you guys sign what's called a CR2A agreement, which binds people in settlement, or you sign a property settlement agreement. Then your settlement is bound and it can't be changed, but you're not going to be able to finalize your divorce and enter it without, if you have children, you cannot finalize a divorce until the parenting plan is entered. However, the opposite is true. If you have children and you have a final parenting plan, you can enter that before you finalize the financials, but you cannot finalize the actual divorce, which requires the division of debts and assets, until you also enter a final parenting plan and child support. You can handle them separately. Very often I'll break up a mediation. I'll do one on financials if it's very complicated. I'll do another on the parenting plan. But most of the time that doesn't happen because it'll usually be a continuation of the prior mediation because people want a global settlements. I mean, very often I'll tell my client, why would you settle that when we haven't settled the other part? If there's things that are interconnected, or if someone just wants to be sure that everything's going to be settled. It can also be used for leverage with the other party to be like, well, no, if you're not going to agree on what I want here, I'm not going to agree on what you want. So yes, you can bifurcate the issues, but no, you can't finalize a divorce without all of them. So I talked briefly about child support. I want to be sure and talk about something that you should know. If you are trying to modify a parenting plan, if you are trying to do anything, this is something that is coming up now in family court. If you're trying to do anything, if you're trying to modify a plan and change child support, or modify a plan and seek attorney fees because you had to get a restraining order because the other party did something, if you're in front of the court, and even if it's not to ask for, you're not asking for spousal support, you're not asking for the property to be divided, you still have to provide financials to get that relief. A lot of people don't understand that. They're like, I want to say this or that happened. Well, that's fine, but you have to have financials in the court file, or the court will not consider your request. Local Family Law Rule 10 in King County, it's always applied, and the courts now are taking it a step further with something that's happening where if you're going in to seek emergency relief, there better be financials in the file if you're asking for anything related to money. So don't give your attorneys a hard time about getting them your financials. We are handicapped when we don't have your financials, because we can't go to court and not get you anything because they're going to say, we don't have your financials. We can't grant that request. So no one's trying to give you a hard time by asking about update your financials, get us this. You'll also have to have a financial declaration on file. And the way you think about it is all that list of things I told you to have, that underlies what you're putting on your financial declaration. So the expenses need to match up with the statements. You have to have that to get relief. Doing a financial declaration is one of the most important things that you can do in a family law case accurately. And you should use an attorney to help you know if the court's going to think your expenses are reasonable. Don't put down a crazy amount of money for Botox. Court's not going to think that's reasonable. Any number of other things too. Don't say that you're spending $3,000 a month eating out. Courts, that's going to not look good. So any number of things are really important, but the financial declaration is critical. And having that and the financials, anytime right now you're seeking relief, err on the side of caution and do it. Otherwise, your case is probably not going to be heard. Any other question, and I'll move on.
Yeah, we've got a couple more. I'll do this one. If a spouse gives up his interest ownership of an LLC that was set up during the marriage, in preparation for divorce after DV, is this regarded as a sorry, I'm not being very clear. Is
This
this
is too fact specific. I don't really want to get into this. Like if you're, I think the general principle here is if someone does something before a divorce is finalized and transfers ownership, is it no longer community property? Yes, it is. And the reason why is you'll have somebody even quit claim off of a property during a divorce because of a refinance or to organize things differently. Name on title does not matter during a divorce unless you very specifically disclaimed a community property interest. Taking your name off something during a marriage, if you're still married, it doesn't matter if you haven't separated, doesn't matter at all. There could be other specific circumstances with respect to changing the structure of an LLC, changing the title on property, changing the name on an account. I'm going to mention all of those because all of those apply here. Name on title in the community property state doesn't matter. So unless you did it specifically to change the character and there's a writing memorializing that, you shouldn't assume that that's going to be dispositive.
Okay. This is a good question. What if a client later decides they do not want the CR2A terms they signed and agreed to? Can they still go to trial? And if
No.
you did, would that suspend the maintenance payments until trial?
No, if you're thinking that and you sign a CR2A and you regret it, too bad, so sad. You should have talked to your attorney beforehand. And I'm not trying to make light of that, but like if you sign a CR2A in mediation, you were told that this was going to be binding. You were told not to sign this unless you were sure. You were told and you signed something saying on there that this is enforceable, even if the orders haven't been entered in court. And the worst thing is when someone comes to us and they want help to undo something like that. Have I ever seen a CR2A agreement overturned? Yeah. You want to know how many times in 15 years? Twice. You want to know how many CR2As I've been part of? Over 1,000. So the answer is no. And it has to be really, really extreme circumstances. Undue influence, fraud, a number of things. And those are not just like, oh, I didn't know, or my attorney didn't explain to me, or I was tired. No, like you are not going to get that CR2A thrown out. I'd bet against it. Could it possibly happen? Sure. Can I promise you it won't happen? No, but don't come here thinking that. Don't do it. And don't think that if you go to court, no, you can't go to trial because your case is settled. You either then have to try and bring a motion to have the CR2A set aside, or the other party brings a motion to have it enforced. And I'm telling you what, you'll probably lose and you'll pay attorney fees. So sometimes you have to live with the decisions that you made. I hate to say that, but such is true. Such is life.
There's another good question related to debts. What happens to debt payments such as a family home, family car loans since the divorce filing, but until the final settlement is reached? What happens to those payments in between?
Well, I mean, you probably have temporary orders saying who's paying what. If you don't, you should
Yeah,
probably get them. Temporary orders, this is a financial hot topic too that I'm going to talk about.
good.
Getting temporary orders, this is what I was going to bring up. So these questions are good because they're helping me hit on these. And this isn't a comprehensive financial deep dive. We did one of those that you can find on our YouTube channel, and I'll probably do another one again. I like to do one in the beginning of the year. Or you can come to my meetup in person next week and chat with me about it if you'd like. But that's another story. So the thing that you need to know about this is if I have debts to pay, everybody has debts to pay. I got a mortgage, I got car payments, I've got credit card payments, we got tuition for our kid. Who's going to pay those things before the divorce is finalized? There's two people, we've separated. Who's responsible for what? A temporary order in your case can be by agreement or it can be entered by the court. If it's entered by the court or by agreement, it's an order that you have to follow that allocates who's going to pay what mortgage, who's going to pay for what while the case is going on. So that's really, really, really important for you to know. In that circumstance, the hot topic that's linked to that is twofold. One, if you need a temporary orders hearing, if that's what you need, you better get one scheduled early right away. You better work with your attorney. And when your attorney says, do you want to do this? And you're on the fence and you're like, I don't know, maybe I shouldn't. I don't want to go to court. Set the dang hearing. Set the hearing. And then if you can work it out beforehand, great. But what happens is people are non-committal. They don't want to go ahead. And right now we are in December. You're not getting a hearing in Seattle till February. So set your hearing date. And once the spots are filled up for the hearing dates, they are gone. You're not getting one unless something happens to open up. So if you need relief, it's not immediate. It used to be we could get a hearing in 14 days almost any time. That is no longer the way it works in King County. And other places it can be even longer. So some places it can be shorter. But as a general rule of thumb, if you need to determine who's going to pay what debts, you need to get on the calendar and get something scheduled unless your attorney can work out an agreement, which sometimes can happen. But at least reserve the dang date. And you got to file things in advance and have your financials filed to do that. So that's super, super important. The other thing related to debt payments, if you don't have a temporary order, then what? Well, this is very important. An automatic temporary financial restraint issues in absolutely every case that is every divorce case that's filed. And when that or legal separation, when that's filed, it says people have to basically maintain the status quo. You cannot take your spouse off your car insurance or stop paying for their car insurance if you've always been paying for it. Same with their cell phone. You can't drain your bank account. You can't basically do anything. You have to maintain the status quo. So basically, if you were paying the bills, you better keep doing it or you're going to look bad and be in violation of the automatic TRO until you go and get a temporary order that says, no, this person should now start paying this. Do not engage in self-help, which means doing something that you think is right, because there is a temporary financial restraint that says maintain the status quo and no one should do anything out of the ordinary course of business. So, and you can't shut people off of things. So get a temporary order if you want to make changes to your status quo. That is the big takeaway. And don't wait to do it. Hot topic right now, waiting will not serve you well, especially at the end of the year when calendars are at a premium. And in the beginning of the year, they're even more busy because people are finalizing their divorces in January. They're filing. The busiest divorce season is between January and March when people want to make changes and file. So get ahead of it now. Fair?
Yeah.
One more
Yeah.
question.
Okay, when you were talking about keeping things status quo, this person's asking, does the court consider paying for your new partner's expenses or her children's expenses while the divorce is still ongoing as reasonable?
No. You know how bad you would look if you went in and you were like, I'm sorry, I've got to pay for my girlfriend's kids, this or that. No, they should no. And actually, from an optics perspective, if you ask for that or the other spouse asks for that, they're going to look pretty bad. I mean, it'd be different. I mean, no, your household expenses, like, hey, I have a household and there's this many people in my house. And so food is this much, maybe. But even then, no, it should be you and your kids. You should not be trying to say, I have a bigger cost here because I have other people living with me. They're not your financial obligation. The court is always going to say you need to pay for the spouse that you're not divorced yet first before you have to pay for anyone else. So yeah,
Thank you.
I can go on. We have another one, or I can move on to one of the last things I want to touch on because this is a
We
brief
do
session.
have a few more.
Okay.
We do a couple more. Okay, what if all of the finances are controlled by my spouse? What if I don't have access to my finances?
Then you need to get access. You need to get an attorney. You need to get financial. You need to basically either serve discovery and get access to financials. That's another thing you need to do. Or if you file a motion for temporary spousal support, temporary child support, anything like that. Like I said, both parties are required to provide financials. If you don't have them, you can say, I don't have them. The other party will have to provide them. You just have to explain why you don't have them. They will have to provide them. And you'll want to do discovery so you know know what they have and what you're asking for. So you can get access. Just because you don't have access doesn't mean you're cut off, but it could take a little bit of work to do so. It's just important for you to know that you need transparency. You deserve transparency. You cannot make educated financial decisions on how to settle your case or what you're entitled to if you don't know how much money there is, right? That doesn't make any sense. You need the information. When you have the information, you can make the decisions. So can the court.
Yeah.
Yeah. I'll take one more and then I'll touch on one more thing.
Okay, if a spouse quits his job before filing for divorce, can he be exempt from paying the debts?
Not necessarily. It depends. I was just discussing this with someone else. There's a thing called imputed income. If your spouse quits their job and they're not just to basically not have to pay for anything or not pay you spousal support, courts don't like that. And then they're going to be expected to try to get another job. They could be imputed to their last known income and be responsible for paying for things. But if they don't have a job because they got laid off and they've been able to find one, that's a different scenario. But quitting your job in the middle of a divorce and just being like, oh, this is going to make me not have to make debt payments, you're going to look terrible. I like to remind you of one word: optics. What are the optics? What's that going to look like if you quit your job? Or what's that going to look like? I had a case once where somebody was making $250,000 a year and supporting the family for the last several years. And then they're like, yeah, I think instead I'm going to go back to school part-time and I'm going to work at Home Depot. How do you think that looked? Looked bad. They got slapped with everything. So you need to make decisions during a divorce that reflect your current status quo. And you might not like it, but you have to do it. On the flip side of that, if you're not working and you are choosing not to work, you got to start looking to try to find a job. You can't just be like, I haven't worked ever and I'm not going to work. That doesn't matter. You'll still be imputed income because you're voluntarily or underemployed. Doesn't mean you have to get a job immediately. And maybe sometimes you get a job and it's not that great, but at least it shows what you're able to get with the skills that you have. So it works both ways. I hope that helps.
Okay.
Yeah. Last thing.
Yeah, hit on your last topic.
Yeah, then I'll take another one. Last thing I really, really, really want to touch on, because these is hot topics. Don't wait to schedule a hearing. Always have your financials in front of the court. These are things that are coming up. The other thing is attorney fees, and we need to talk about this, okay? Divorce, family law at all, it's expensive. I mean, it is. And I say that as an attorney, and you might just think, oh, well, I read something in a forum today. It was laughable. Attorneys, and it might not be to you, but attorneys just want as much drama and chaos in your case because that's how we make money. True, we make money the more work we have to do. But guess what? We're human beings too. And we have more than enough clients. We want you to settle your case. We want you to be happy. We want you to move on. We are not trying to drive your drama. What I was going to say is this. People ask me at the beginning of every case, more than ever, how much is this going to cost? And they want an answer. And everybody's contract is going to say that we don't know, because we don't know. We don't have a crystal ball. If I like a crystal ball and I could say this is going to happen, I sure as heck wouldn't be doing this. I would go and just place all the bets in the world and never work again, as would you, right? So this is the thing. How much is this going to cost? Here is the answer. I hope you're listening. This is going to cost exactly as much as you and your spouse make it cost. I will say it again. This is going to cost as much as you and your spouse make it cost. You might be like, wait, hey, I'm chill. I'm going to provide my financials. I just want what's fair. Yes, that is actually true. However, the other party might be angry, might think that, oh, they might think something like, this person wronged me and accused me of domestic violence and I didn't do it. Or this party said I withhold my kids and I didn't do it. I should be entitled to money for that. No, this is a no-fault state. You cannot ask for money because you think someone did you wrong. You can't do that. So you'll have to defend on that. You'll have to explain it. The point is that person's going to cost you money. And that's really crappy. You can try to seek attorney fees based on what is called intransigent. If someone actually lied about you or wasted the court's time, then in that proceeding, you could ask for fees. But a lot of the time, you're not going to get them. You're not going to get attorney fees because people have the right to make allegations. You cannot come back later in settlement and be like, they accused me of this and it made the case cost more, so I should get more of the money. It doesn't work that way. So my point and my takeaway about attorney's fees is be fair, be firm, but also be friendly until there's a reason not to be, because it's only going to cost you both money that you could be dividing. And we don't want to make money off your misery. Frankly, we don't. We want to help you get through your problems and move on. Nobody likes the case that costs $200,000 to settle, because guess what? Even though I'm not being paid for it, I have to think about it every night. It doesn't just like leave my brain like poof, like that's not worth it, you know? Or I would much rather have the case that costs 15 and everybody kind of got along and we worked out some good issues and people went on their way and they were able to start their lives over. So be fair, firm, and friendly, and realize you cannot control your crazy narcissistic spouse. If they're going to act like that, you can't control it. The best you can do is not also engage in escalating the conflict. So I hope that helps. I have time for a couple of more. I just wanted to touch on those hot topics. If you would like to do the financial deep dive, I would encourage you to look for that on our YouTube channel or join us another time. Melissa, do we have a couple questions?
Yeah, somebody's asking a pretty specific question, so I'm going to try to take it away from the specifics. They're basically saying they have a CIR case. They were together for 14 years. She was the breadwinner. He was working on the home and wasn't really working. And so here they are trying to, figure out a settlement, and they're wondering what they need to provide. They said they just don't really have many accounts. So they have like 6 months of bank statements, but what else do they have to provide in
If
trying
you
to?
have real property, you're going to need to probably, depends on what's going to happen with the property. Is one party going to keep it and buy the other one out? If so, you're going to need an appraisal. You also might want a CMA, like a comparative market analysis. So you're going to also need to value any property and any businesses. Those don't need to happen just anytime you're asking for relief, but if you're working on settlement, those things do need to happen. And in a CIR case, usually the person who has more assets wants to say there was not a CIR or the CIR started later. So you're going to need to very fundamentally understand when that CIR began. If you're agreeing that it did, or if you're not agreeing that it did, you're going to need to understand what you're going to do to have to deal with that. So CIR cases can be a little murky, and they're also really great cases. So we do a lot of those. And I think there's a lot of issues for you to know about. A big thing is, when did it start and when did it stop? And what is the value of any assets in between? So I hope that helps. I could take one more.
Well, there's a question here about more information on the in-person upcoming
The in
meetup.
person, yeah. So let me talk about
Meetup.
meetup. I have a minute. I'll talk about meetup, and then Melissa will put up our contact information. Go to
Mhm.
our website. It's dellinolaw.com. Go to news and resources. Meetup. We sponsor a monthly meetup. It's hosted by meetup.com as far as the site where you can sign up. And usually every quarter we do an in-person one. We usually don't do one in December because everybody's traveling or doing different things. But I think December is a time when people are stressed out. They've had it up to here with their family law case, right? I mean, I know I've had it up to here, and it's not even my case, right? You've had it up to here because there's a lot of stuff going on this time of year. I got to go to a company holiday party. I got to worry about my residential schedule with my kids. This is my first Christmas without my kids living with me, or since my divorce. Come and talk to us about it. So next week, on the 18th,
Wednesday the 18th.
yeah, Wednesday the 18th in Bellevue, I believe at Cascadia Pizza. We've been doing them there for years. They have a nice room. We order some food. We can come. We can talk about different things. We're doing it in person that night. We'll do one every quarter. Besides that, our meetups are on Zoom. You can go to the link from our website and sign up on meetup.com. Really encourage you to do that. The capacity for the in-person is limited, but the online, we can have a lot more people there. So if you can come, it's great. I think we start at 5:30, usually go to about 7. So if you can come, and if you sign up, please come, because if you sign up and don't come, you're taking a spot from somebody else that could. So obviously things come up, but if you think you can make it, sign up. I think there's a few spots left. Yeah. So anyway, other big takeaway for you is, again, this is a really, really, really stressful time of year. And the best thing that you can do is get some help for yourself and get some support. If you don't have a therapist, reach out to Melissa or somebody else in your network, because I can tell you this, if you're going through a family law case, again, I'm going to come back to optics. You look better for the court if you have a therapist and you have kids, or someone's accusing you of DV. You really do, especially a therapist that will be on your side. But forget about the optics for a minute. What about you? What about you? Calm down, take a minute, find somebody to talk to, because it's going to save on your attorney fees as much. If you are talking to me or another attorney about he did this or that, I mean, I want to hear it. Yeah, I'm happy to talk about it. I'm not a therapist. I can't help you deal with the stress or move on from it. I'm usually like, get a therapist, because I'm charging you because this is my time, and it makes me feel bad to do that. I don't want to charge you money that I don't have to charge you. I want to help you solve your legal problems. A therapist can help you be more effective in your legal representation and give you some good optics. So Melissa can talk about that for a minute. I need to log off, but I want to say thank you for coming with the good questions. Money can be a hot button issue to talk about. It can be really, really difficult. But by being willing to come and ask the questions and do that, you guys are actually contributing to the community, because someone gets to hear your questions. And also people just get to know, hey, I'm not the only person watching this. So anyway, and every time somebody tells me, hey, I watched this on your YouTube, or I watched this on your webinar, I'm glad, because The only reason that we do this, sure, it'd be great if you hired us, but that's not why we're here. I don't need you to hire me. I need you to take something away from this and make your life better and make your family law situation less stressful, because that's going to make life better for you, your family, your kids, your dog, whatever it is. Take one bit of information away from this, and that is that you will get through this. So thank you so much. Have a great day. And special thanks to Melissa for hosting this and dealing with me talking especially fast today.
Thanks, Michelle.
Take care. Bye-bye.
Thanks, Michelle. Yeah, just one more sort of plug as to what Michelle was saying. When we're talking about financial topics and family law, being able to have adequate support really is a money saver. I work with a lot of clients who are going through their family law cases, and being able to provide support for people and enable them to kind of, find out how to be most grounded, be able to compartmentalize their stress, be able to, explore their coping strategies and work through those hard things, outside of their attorney meetings, and be able to show up to their mediation, and be able to show up to the meetings that they have with their attorney, and even be able to show up to the dynamic that they're still involved in with their ex who they're, divorcing from, is, really, really beneficial to be able to come up as healthy as possible throughout this process. And it'll save you money by not, having to engage in more conflict in the legal side than you already are. So I'm going to leave this slide up here for just a moment. Feel free to reach out to Michelle's firm if you're interested in engaging in a family law consultation. You can reach out to me if you're interested in counseling, and wish you all a happy holidays. All right, take care.